Well, good afternoon, everyone. We're going to get started in just a minute. Just waiting for everybody to be able to get into the room. All right, good afternoon, everyone. Welcome back. Thank you for joining CCI Huronia for our last Lunch and Learn webinar for 2021. Hard to believe we made it through another year of some really great webinars. Today, we're going to be talking about condo cases. My name is Sonja Hodis. I'm one of the many directors at CCI Huronia and a condo lawyer, as well as your moderator today and one of the speakers. But I have with me two other condo lawyers who are going to go through some cases with us. We have Patricia Elia from Elia Associates and Gareth Stackhouse from Common Ground Condo Law joining us on the panel today. Patricia, Gareth, and myself, we're going to take you through 2021 cases from the court and from the Condominium Authority Tribunal, which we're going to be referring to as CAT throughout the webinar. And we're going to discuss how these adjudicative forums are deciding issues that affect condos, issues like owners behaving badly, and pets and storage. So stay tuned, snuggle up on your recliner, put another log on the fire, grab your cup of cocoa, your eggnog, or something else that may be appropriate on a Friday afternoon. We're not going to judge. Sit back, listen to what we have to tell you, and find out who is on the naughty or nice list. All right, sorry about that. So before we get started, as always, we need to thank our sponsors because without them, we're not able to put on these webinars free of charge to those attending. So thank you to our sponsors who have been loyal sponsors for the fall-winter webinar series, Integrity Property Management, Elia Associates Condominium Lawyers, and FCS Fire Consulting Services Limited. If you want any information about these sponsors, just click on their logos on our website and that will direct you directly to their websites. So thank you again to all of our sponsors. So before we get started, I just want to make sure if this is your first time joining us, you know who the Canadian Condominium Institute is. We are an independent nonprofit organization formed in 1982. We have chapters across the country and 8 alone in Ontario. CCI Huronia is one of those Ontario chapters, and we are last year's winner of the Lauren Young Chapter of the Year Award for Tier 1. CCI's main objective is education. However, CCI also advocates for condos, and we represent all those involved in condos, from owners to directors to professionals, and we encourage all those stakeholders to work together. If you are not a member of CCI and you're thinking of doing so, great gift for Christmas coming up, you can check out one of your local chapters and consider joining today. You can find a chapter near you by clicking on the national website, cci.ca, or if you would like to be a member of CCI Huronia, you can come directly to our website, ccihuronia.com, click on the membership tab, and you can join online. In addition, CCI National has a resource center, which has a great deal of material available for review on condo-related issues, and you can access this on the national website at cci.ca, or you can go to the CCI Huronia website and click on the resource center tab, and it will direct you there. Don't forget to follow and like CCI Huronia on Facebook to find out about our upcoming events and learn about all of our professional members. There's posts that are going up weekly showcasing our professional members. And also always check out our website, ccihuronia.com, for upcoming events. And if you are not on our email list and you want to be, to get our newsletter and get information about what's happening at CCI Huronia, just send an email to admin@ccihuronia.com, ask to be added to our mailing list. And if you want to check out our past editions of our newsletter, Condo Buzz, they are available on our website as well. And as with every webinar, we are recording this webinar, and a recording of the webinar will be posted on our website next week. If you've missed any of our previous webinars, just go to our website, ccihuronia.com, click under the resource content tab, and watch our previous webinars. Make sure when you do watch them that you like our videos and share them, and don't forget to subscribe to our channel. During this webinar, we are going to ask everyone to keep their mics muted. If you want to leave your cameras on, feel free to do so. If you don't, just turn off your camera. At the end of the webinar, we are going to be taking questions. So if you would like to put questions into the chat box, you can do so during the webinar, and we will address them at the end. And if you would like to ask a question live, we'll see if we have some time at the end, and we'll do that by using the raise hand feature. And then finally, the information that you're being provided today is general information, may not apply to your specific fact situation. CCI Huronia is wanting to make sure that everybody's aware that if you want to take advantage of the provisions in the Condominium Act that protect directors, that you need to get your own independent professional advice about your specific fact situation. The information today is not intended to provide you with that type of protection. And finally, the information today is current as of December 17th, 2021. So now that we've gotten through some of the housekeeping matters, let's get started. Gareth, you're going to start off with our story, our storytelling today, and you're going to talk about all those owners who are on Santa's naughty list.
Oh, and Sonja, thank you so much. And thank you everybody at CCI Huronia for coming out today and wanting to listen to us talk. I wish these folks were on the naughty list. There's probably a list below that somewhere that they are actually or should actually be on. I know that Sonja, CCIH, put up a list of all the cases we're talking about today. And there is a laundry list of cases from 2021 about people not behaving well in condos. There's about 6 or 7 I'm going to chat about. There's one called Halton Condo 77 in Mitrovic. That was from the start of this year, March 2021. And that was a case where people didn't want to wear masks. They just wanted to rove around the condo not wearing masks. They didn't want to do anything they ought to be doing kind of at the height of the pandemic. And this matter went directly to court because the condo said, hey, you guys need to be wearing masks. You can't just be strolling about the common elements unmasked. And the condo actually prevailed in that case. And where they prevailed is under sections, specifically 134 of the Condominium Act. That's called a compliance order. So that's an order from the court where the court will tell somebody, you should not do this. You must not do this, pardon me. And you must do this other thing. It's usually, you must not do the bad things, and you must follow the Condo Act, as well as the declaration rules and maybe a mask bylaw, a mask policy that your condominium has. And we've seen this uptick in folks like the Mitrovics not behaving well. And Justice Myers, in the case I'm going to talk about next called Mills, Justice Myers said exactly what everybody needs to hear. He said, it's trite law that condominiums are a particular form of communal living and that there is some loss of privacy and autonomy. It's endemic to living in a condominium community. Respecting interpersonal boundaries is especially important when one has ongoing close contact with one's neighbors. In more plain language, what Justice Myers had said there is, there are limits on what you can do in a condo. You don't have free reign with whatever you think you want to do. And just like the Mitrovics, we've got a bunch of other folks who were saying, well, I want to do whatever I want to do. There's another case, MTCC 580 in Mills, Toronto case. This is from April of this year. And it was a long and tortured case in a tiny little 15-unit condo where Mr. Mills had he'd run the place ragged. He'd harassed the contractors, the board, the other residents, the management. Justice Myers again actually said, over several years, Mr. Mills had terrorized the community. He played audio recordings. He got charged with criminal harassment of the president of the condo corporation. And all this came together, and the court actually ordered limits on his communication with other people, including the board and management, that he can really only access his unit and not any other part of the condo. He cannot make threats. He cannot make nuisance from noise. But in that case, there was a pattern, like years of bad behavior from this guy. And we'll see that a little bit later, that we don't just get to run directly to court. There really has to be the establishment of a pattern of bad behavior. A further case from May, so next month after the Mills case came out, Carlton Condo 32 in Yakovlev. This was a noise and nuisance case, but it was also, there was harassment and aggression towards other people at the condo, again, directors, residents, contractors. And that really falls under Section 117 of the Condo Act, which is nobody can create a situation that presents a danger to people or property at a condominium. And that's something that we often rely on when we have to go to court or try to enforce situations where they're not just being a nuisance, they're being a danger to everybody else. And there's some other antisocial behavior. They were not wearing their masks, all that sort of stuff. And the court had actually looked at everything, the steps everybody had taken, and said, yep, the condo took all reasonable steps to ensure that the respondents, so the Yakovlevs, complied with the Condo Act and the Declaration, Bylaws, and Rules. And the persistent breaches must be stopped. And again, an order was made that they could not do this laundry list of bad behavior. Got another case, and this is a couple of cases, a series of cases really, from Ottawa again, Ottawa Carlton Standard Condo 671 and Friend. There's a few different cases here. There was just a long-standing dispute kind of simmering over the years between Mr. Friend and the Condominium Corporation. It actually went all the way to the Court of Appeal. And he refused to follow, the court says he's refused to follow, again, the bylaws and the rules, interfered with everybody working at the condo, including contractors and management, engaged in a campaign of harassment, demeaning behavior, physically accosted the president of the board. And again, they said, hey, you can't do that. And they ordered some costs, and they ordered some other costs that they declined to order some other costs that I think we'll talk about a little later in this presentation. But again, there was a long pattern of behavior in this case. There's another case, York Region 794 in Watson, earlier this year. Patricia's actually going to talk about this case. It's one of her cases, but there were just horrendous abuse and threats. And again, the court looked at the entire record and said, the Watsons, you cannot be doing this. You have to stop. They ordered compliance. They ordered costs as well. And then there's another case. It's not been reported yet. It's one of my cases. It's Metro Toronto 1396 in Arsenault. And this is, again, where somebody, Ms. Arsenault, had a 2-year-long pattern of being loud, playing excessive music, screaming at people, harassing her neighbors. It escalated to throwing stones and making death threats. And I'm just going to read a little bit from, again, Justice Myers, what he wrote in his endorsement. He said, first of all, there's admissible evidence. So something that's very important anytime we have to take compliance action is we have to have evidence which is admissible, which means it's been verified. It's not just an email complaint from one resident saying, person upstairs is awful, they're making noise. But that, and then your security or somebody who works for your condo goes upstairs and listens and says, yes, I can verify what happened. Because we cannot, as lawyers, go to court unless we actually have evidence that backs up what we have to say. Justice Myers also said the number of complaints is startling and telling. That the respondent, she asserts an ongoing right to scream and swear, and she's threatened to kill people. And then we get to kind of the costs and the relief that the condo got. Justice Myers, corporation properly tried to mediate and arbitrate this dispute. That's under Section 132 of the Act. We gave her notices of mediation, notice of arbitration. We even said, go buy wireless headphones, because the biggest problem is you love to play loud music. She didn't buy the wireless headphones. Justice Myers, at the outset of this, said, before you hear the case, go buy her a set of headphones. We did that. She picked them up, and then she returned them a few days later. And he said the proceedings required only because of the ongoing conduct and misconduct of the respondent and a refusal to engage in reasonable communication, mediation, or resolution. And in this case, there was a full order to tell her not to do a laundry list of things, to pay all the legal fees, and set it up so that if she violated that order, and this is kind of the relief that you would see in these types of cases, that you violated this court order, and usually it has to be a number of times, the condo then has a right to come back to court and say, dear court, this owner is not compliant. They violated things. We would like the court to order the judicial sale of the unit, to say that person is so bad, and we've given you so many opportunities, you can't live here anymore. We're going to sell your unit, we're going to pay our costs, and then we're going to give you the rest. And in this case, we actually have a date to go back to court in February to do that. However, there's a few things that you cannot do as a condominium when you're looking at these compliance matters. The first one is don't over lawyer. Don't just run up the cost for the sake of running up the costs. You do have to examine the complaints and the proof. Justice Myers talked about in Arsenault. We've got another case that came out yesterday or 2 days ago called TSCC 2204 in Penatugu, where the court said, well, there's no there. If you're going to take compliance action against somebody, you really need to make sure that they've actually done something that breaches your declaration, your bylaws, your rules in the act, and that's verifiable. It's happened a few times. Do not rush to lien for a tiny little amount of money. And don't forget to follow the mediation arbitration procedures in Section 132 of the Act, or go to the Condo Authority Tribunal, which of course currently has jurisdiction over pets, parking, storage, and as of Jan 1, we'll get jurisdiction over disputes about noise and nuisance, odors, all those sorts of good things. Because what we did see in the Ottawa Carleton 671 and Friend case, they didn't mediate that case. The condo actually said, well, we thought we were basically just going to throw away a bunch of costs and it was going to be too hard to mediate it with this guy because he's so obstinate. The court said, you're required by the Condo Act to do this, and we're not going to award you a certain amount of your pre-litigation enforcement costs. It was about $18,000. It's another case, this 2204 case in Penatugu. Justice Dunphy went before him and he looked at said, you're trying to make me order the possession of this unit on the basis of a $1,000 chargeback that didn't really have any complaints to substantiate it, and you didn't go to mediation arbitration. Justice Dunphy started the case off. The motion proceeding should never have happened, and it got worse for the condo from there. It was ordered to go to mediation arbitration with no cost to the condo. So when you're in a compliance situation, the board, the management, and your lawyers, everybody needs to look at it from a holistic perspective and think about, are we taking reasonable and graduated steps? Is everybody doing what they have to? Are other residents suffering? If so, what do we do and how do we get them on board to basically document their suffering, which again, the courts really want to see and hear. So I'll turn it back over to Sonja. I believe Patricia has some more cases to talk about next.
Yeah, thanks, Gareth. And yeah, it's always such a, it's such a delicate balancing act when, especially you're dealing with owners who are really behaving badly, and you know that you're just going to be wasting time trying to be reasonable. But the courts and the tribunal are sending some very clear messages on that. So Patricia, you're going to give us an update on the Watson and YRCC 794 case, because you are intimately familiar with this one.
Yes, it's been near and dear to my heart for quite a while as the counsel to the corporation, and having seen the board work through this with a lot of integrity. And I'd ask everybody to think about when, as we get into thinking about people behaving badly, I want you to think about, should you pay the cost of people behaving badly? And I'll get to my point, and you'll maybe see my bias in my own arguments, both as a condo director and a condo owner as well. But I just wanted to clarify one thing in the Mitrovic case, because one of the things that was interesting in Mitrovic was the fact that the judge did make an allowance and made an exception for the Mitrovics without medical evidence being presented, that they were allowed to go back and forth on the common elements without their masks to their units. Now, when I spoke about the Mitrovic case earlier this year, some of you may know that what drove me crazy was the fact that masks have been proven to be a way of reducing transmission of spread. And therefore, I was not sure what the value of the lives were of the neighbors to the Mitrovics who reside on the same floor. So, to me, the condominium corporation in that case has extra cost, extra vigilance, and perhaps arguably potential other risks to manage. So in terms of the YRCC 794 Watson, Fiddler Robertson, Jade Roberts case, the origins of that started about 2 years ago. And What it was a gradual escalation. And when you read the case, you'll see that what happened was there were allegations that started to manifest from the occupants of this unit. And these people had lived there for quite a many number of years, about 20 years, originally being owners and then becoming occupants. And the allegations ranged from discrimination against people of color or based on gender. It escalated to death threats against board members, death threats against the manager, death threats against security. It escalated to calling out people in the middle of the common elements and saying that they were committing homosexual acts. It resulted in the corporation being in a mindset of fear and people being very, very scared and nervous. In addition to this, there were also involvements with the police, and criminal charges in certain circumstances were laid. And generally, the corporation, and just to follow on Gareth's track here, the corporation management offered to sit down, have a discussion, mediate. Now, here's the thing. When it's Section 117, there's nothing to mediate. Why? Because there's a risk of harm to person or property, and that needs to be managed, which is why we go to court. But the corporation acted in good faith. Now, I mentioned that these folks were occupants. The other issue was who was actually the owner of the unit, because all notices that went to the owner were not being responded to. Turns out that the address that the corporation had on records, which was the unit, was not the proper address for the unit owner to be notified. So the corporation then reset some of the timelines and then gave more notice once they tracked down the owner, because we did do a title search. And it turned out that the owner was not able to deal with the occupants, and they are related. And, the concern was, even if public guardian should be involved or there was something else that we should have had to do to intervene. But there was no cooperation. They had appointed counsel through the unit owners, but counsel then was dismissed. And so we decided we were going to go to court because it had to end. The board lost its president over that, and not just lost a president who had served for 17 years, but also decided to leave the building. It was so hard on this board and this president. So move forward, we go to court, we adduce all the evidence that I've talked to you about and then some. And the court says, you're right, this occupancy has to end. And this order, we're going to order that they sell the unit, that they have to leave. Okay. So we get the order, we're effecting removal. And the sheriff's office says, no, we can't do anything. They don't want to leave. We're not going to be able to intervene. And we're questioning now what is going to happen. So we had to go back to court, a different judge, and get another order. So there was a second order in this case. And this order was where the court ended up finding that the occupants were trespassing. The court then confirmed that the occupants were in breach of the prior orders, therefore contempt, and that the unit owner is obligated to list and sell the unit. The order itself set out the relief that we required. And what we found difficult here was in the first order, we got all of our costs. In the second order, we did not. And I thought that was very interesting. The unit owner attended, confirmed that she wanted the occupants removed, and the court still did not award the corporation full costs. This was a little bit of a blow, I thought, because this was all with respect to the original order and enforcement. If anything, it should have been abundantly clear that this was in the same strand. There was nothing new being tabled, except for the fact that they were breaching the order and we were trying to get more authority to have them removed. Ultimately, removal did happen. The police had to attend. Once the police attended, the unit, the locks were changed. These people tried to revisit the unit, And, we had to call the police again. So, real lives were impacted by this. Real lives were, and a community ended up paying a significant amount of money to have these individuals removed. And so that's why I asked, is it fair for the unit owners who were living in this sort of terrifying set of circumstances, unpredictable, uncomfortable, damaging their peace of mind, should they pay for the costs? And my position will be no, they should not. And that's not what consumer protection is, and that's not the premise upon which the Condominium Act was drafted. Condominium Act specifically provides for the ability to transfer the costs of behaving badly back to the party who was behaving badly. As it is, condominium owners are now paying for the infrastructure of the CAO and the CAT. And then to also have to pay for the costs of enforcement seems a little bit much. It's almost triple taxation, in my opinion, not even double. So I think we need to be really cognizant about that and where we go with that. And, I think the idea to resolve disputes early on, really important. Take the opportunity, don't dismiss it. But at the same time, myself as a mediator and having studied this, you can only really mediate if the parties want to. So really, you need to do the work to understand what the common ground might be for the parties to have a discussion, to actually understand what the penalties might be that are imposed by the court, which are not granting costs because you didn't show good faith and you didn't do what your bylaws prescribed or the act prescribed. So I think that's where we have to now really take it seriously. The courts, if you look at the decisions that are coming out, are really not happy doing condo work, only in certain circumstances where they appreciate the risk. And, in the news case that Gareth talked about, I actually agree with the judge in that one, because I also felt that what happened is they turned the dispute around from something that is a nuisance to trying to sell somebody's condo without doing all the other steps in between. You can't jump that prematurely. And you have to follow the threads of the law to understand where we're evolving to. So thanks, Sonja. Back to you.
Thanks, Patricia. And I think, that last comment you made is a really important one about, taking that big step of going to sell a condo. I don't think there's any value in trying to enforce a $1,000 lien by forcing a sale. You're going to get your money eventually. It's good. You're just going to wait for it. But, that's why the courts get upset, right? When you start off with $1,000 and you end up with 20, because you're going through the lien process and trying to force the sale. That's not, no condo is going to look in good lights at that point in time. So it is about being reasonable, but it's hard sometimes, right? Because sometimes you're dealing with very difficult owners who are very much not going to compromise or be reasonable, and their actions are affecting a lot of people.
Yeah, and I think one of the things that was also problematic in the case was it also appeared that the court, or the condo corp, had taken sides. In nuisance disputes, especially when you're really looking at the role of the condo, you have to be very careful of how you architect that dispute, because if it's between people, it's between unit owners, and what's the role of the corp, right? We all know we've done noise cases, but we should also make sure that we're being objective where we have to be objective. We should not pick sides, because that's not our jobs either.
Yeah, for sure. All right. So I'm going to now sort of shift things around, and I'm going to focus on sort of giving an update on some of the CAT cases from the tribunal over 2021 that I thought were interesting and highlight a couple of good lessons to take away. And then we'll go back to Gareth, who is going to take us on our next round of cases. So as we all know, at the end of 2020, CAT's jurisdiction expanded to include pets and parking and storage, so they weren't just dealing with records anymore. And as Gareth already alluded to, come January, their jurisdiction is going to expand even further to deal with nuisance-type claims. So let's take a look at how CAT has been handling these disputes with their expanded jurisdiction over the last year. And one of the first ones that I want to talk about, and just talk about very briefly, but I think it's just a good reminder on the records issue, which CAT has been dealing with since the beginning. And this is the Zamfir versus York Condo Corporation 238 case. This is from just a couple of days ago, actually, from December 13th. And it's just in time for Christmas, but unfortunately, CAT did not hand out a Christmas present for the Condo Corporation, because what they did is they gave them a penalty of $1,000 for not completing their response to requests for records within the 30-day time period, even though the Condo Corp acknowledged that they have a duty to do so and they promised to do so in the future. The CAT said that it was very important to impose this quite large penalty of $1,000 to just remind them that they have this duty. So if you don't want to be running the risk, make sure you get those responses in within the 30-day time limit. The next one I wanted to talk about is the Calderon and York Condo 274 case. This is from July of this year. And this case talks about, we've mentioned this term before on our past webinars, vexatious litigants. And there's a couple of, very popular, famous cases out there about vexatious litigants. I know Patricia knows all about them. She's had a few of these cases, but this was about a vexatious litigant at CAT. And this owner, Calderon, he started 8 cases in total at CAT. And at the time of this motion, he still had 5 cases that were ongoing. And the Condo Corp tried to declare him a vexatious litigant, and that there would be an order restricting him from using or having access to the tribunal. And so at the end of the day, unfortunately, the motion was denied. And it's interesting because the CAT recognized that 8 cases seemed to be quite a bit of cases before the tribunal, but they felt that there was a common theme, that the owner was questioning the fairness and the consistency of the corporation's enforcement of the rules. And the fact was that none of the issues had been determined yet, and it wasn't obvious that these cases wouldn't succeed. So the good news is that at the end of the day, the tribunal did give a warning to this owner and to all owners that the CAT is really not to be used to bring issues about whether condos should be self-managed or have property management. The bad news is that 8 cases is not enough cases to deem someone a vexatious litigant. And that's really unfortunate for condos, because there's a lot of expense being incurred dealing with all of these cases. And Gareth and Patricia and I have all been talking about costs, and we're going to talk about costs some more at the end of this webinar, but it's a real reality that condos have to face. And at CAT, costs are such a big issue because it's not a cheap and cost-effective way to resolve disputes. It actually takes a lot of time to deal with the processes in CAT. And unfortunately, we're not seeing condos being given the cost awards that they should. And we're going to talk about that in more detail. I'm not going to get into that just yet. But in terms of this vexatious litigant case, just to let people know that there is an ability to try and bring a motion to deem someone a vexatious litigant, but you're going to need a lot of cases to that they filed to be able to do it, because 8 is not enough. Another one that I wanted to talk about in terms of CAT decisions is the Soros versus York Region 1445 case from September of this year. And the reason this case is interesting, the next 2 cases I'm going to talk about are really focusing on how you define terms. And so this case was about seasonal furniture. And this condo had the typical rule, only seasonal furniture allowed on balconies, not allowed to use your balcony for any other type of storage. And the owner in this case, what he did is he took a structure that was originally intended to be used to store weights and barbells. He converted it into a table, and he claimed this was seasonal furniture because in the summer he hung flower baskets on this table / weight barbell storage. And in the wintertime around Christmas, he hung lights. So he said it is seasonal furniture. Now, seasonal furniture was not defined in the rules. So there was no clear definition of what seasonal furniture was. And so in this case, interestingly, the CAT member said, well, let's look to Google for an ordinary understanding of what that term means in the context of a condo balcony. And they found that the search on Google did not provide a structure that looked anything like what the owner had created. And the tribunal also noted that the owner did not buy the structure with the intention of using it as a table. And the fact that he hung flower baskets and lights, that was just for limited periods of time. So when those flower baskets and lights weren't on the structure, it really was just a structure being stored and therefore was a breach of the rule. So he was ordered to remove the structure. Unfortunately, no costs were given to the condo to enforce their rules. So in this case, tribunal says, let's look to Google and see how are these terms normally defined. And I don't know if you can Google seasonal furniture, condo balconies, if you get a standard look of what that is supposed to look like, but that's what the tribunal says we can do. On the other hand, we had another case in April of 2021, the Boodram case, Boodram versus Peel Condo 843. And this was a visitor parking case. And the whole issue was, is this car a visitor's car? The declaration, again, very typical, no residents are permitted to park in visitor parking. And we had policies that were related to the issue of visitor parking permits and enforcement, but there was no clear definition in the governing documents about what was a guest or what was a resident, who those people were and how they were defined. So we had a Honda CRV that visited the condo frequently. They used the visitor parking spot or they parked on a road near the condo. And based on the frequency and use of the visitor parking, the condo declared this driver, this car, to be a resident, not a visitor. They didn't allow him to park in visitor parking anymore. The owner disputed this. But at the end of the day, what was really interesting is that the tribunal found that there was no determinative evidence that the driver was a resident. So neither the condo nor the owner could provide enough satisfactory evidence to determine if this car and the owner of this car was actually a resident or a visitor. So the tribunal said, we're not going to make a decision on that. But at the end of the day, the condo lost because they weren't able to show that this was a violation. And the tribunal also made a big point of saying that there was no clear definition in the documents, the governing documents, as to what was a visitor or who was a visitor or who was a resident. And therefore, the condo corp was not acting reasonably when they were determining if this car was a visitor car or not, because there was no way that they could determine it. So they suggested that the condo go back and clearly define what a visitor is and what a resident is in their rules. In terms of the policies, they also made a point of saying that the policies, and we've talked about this before, policies are not enforceable. They're not, there's no provision in the Act that allows you to enforce a policy. So if you want to create an obligation, you want to make sure that you put that into your rules and leave policies for procedures. So then there's another parking case that I just want to touch on briefly before my time is up. This is Davey versus Toronto Standard Condo Corp 2121 from December of this year. And again, another visitor parking issue. In this case, the owner wanted to use the visitor parking to park a vehicle that she got on loan from a family member from time to time. She didn't actually own a vehicle herself, but she used this loaner vehicle for her personal use. She claimed that she should be able to park this in the visitor parking. Condo wouldn't give her a visitor parking pass anymore. Interesting enough, the owner had her own parking spot, but she leased it out to make a little bit of extra money. But she thought, well, that's my right to do so. And the condo didn't dispute that it was her right to lease out that spot. But she also wanted to be able to use the visitor parking. The court, or CAT, found that the board was entitled to uphold the no parking in the visitor parking spaces. So it's nice to know that the CAT came down on the right side on this one. But again, unfortunately, Condo does not get any costs to enforce the rules, which is really, really sad. So I've got a couple more cases. I'll leave them to the end if we have some time, because time is running very quickly. I'm going to pass it back to Gareth. And Gareth, you're going to talk about your human rights case that you had recently at CAT and how CAT dealt with the request for accommodation.
Correct, Sonja. Thank you very much. And we'll try to be judicious with the time on this. This is a case, it's called Martis and PCC 253, so Peel Condo Corporation 253. A little bit of background about PCC 253. And it's a kind of mid-rise building. I think they've got about 115, 120 units. And they have had a no pets rule in place since 1998, so 20 plus years. And there are a lot of people who live at that condo. And one of the reasons they live there is they don't like dogs. They're afraid of dogs. They're allergic to dogs. They have religious objections to dogs. And I'm saying dogs because dogs are the pets you see on the common elements coming in and out. Generally, you don't go walk your goldfish. But the condo has a lot of people who live there who actually like it for the fact that it doesn't have pets. What this condo then gets, and they've got an uptick of this in the past few years, is a lot of folks saying, I would like what's called human rights code accommodation for an animal as an emotional support animal. I have a medical letter from a medical professional that says I have what's called a disability under the Human Rights Code, and my disability can get treated or treated in part because I have an emotional support animal that helps me emotionally in some way. And just as a reminder, the Human Rights Code takes what we call paramountcy, so it sits on top, overarching, over top of the Condo Act. That's a function of the Human Rights Code. It kind of sits over top of all other statutes that we've got in the province, unless that statute specifically says it doesn't. So we have to, in condos, think when somebody says, I have a disability or I have a need on the basis of, it's called family status or age or whatever, I have a need for accommodation. You need to vary your rule or give me like basically a hall pass effectively to do something different. And this case really hinged on, can a condo say, yes, we are going to give you accommodation for your emotional support animal, but we would like to put reasonable restrictions on that support animal in order to balance the needs of our community. And in this case, Mrs. Martis, her son, adult son, said, I live with my mom. I need a support animal. I've been prescribed one. And went back and forth with management about it, got some info, and management had said there are limits on the size of the dog, and later there are limits on the size and the weight of the dog. And he unfortunately went and got a dog that was like 60 to 70 pounds fully grown. This condo asks everybody to, when they get an emotional support animal, to have a dog that is 25 pounds or less, about that way. And the reason for that is they really ask folks to be considerate and judicious about how they transport that dog through the common elements, because they've got all these folks who are allergic or scared or object to dogs. So please make sure you carry your animal or put it in a little doggy cart through the common elements. Ask everybody in the elevator, if there's other folks in the elevator, if you can get on with the dog first. Go out, the side door, not through the main lobby. Again, this is really, really to balance the interests. So we ended up at the Condo Authority Tribunal. There was a bunch of letter writing back and forth between lawyers, and there were claims saying you have to accommodate us under the Human Rights Code. And then the lawyers for the Martis family said, well, rather than going to the Human Rights Tribunal, which is the tribunal that decides on the Human Rights Code, we're going to go to the Condominium Authority Tribunal, because the Condominium Authority Tribunal has jurisdiction over pets in condos. And this is an issue of pets in condos. Even though we are seeking, accommodation for this animal under the Human Rights Code, potentially. Now, Sonja touched on the Boudram case about policies versus rules, something that the condo, in this case, PL 253, had in place, literally as a draft the board was considering at the time that Mr. Martis asked for accommodation was, could we put together a policy that would guide residents about how to ask for accommodation, the medical information they need to give us, and then a list of the reasonable restrictions that they might expect depending on their individual need if we do accommodate them. And that policy was in draft. This was well before the Boudram case came out and told us, that you can't have a policy that pretends to be a rule. And in this case, the Martis case, the member actually looked at all this at the policy because they had impugned the policy, and the member said a policy may exist validly for a number of purposes, and two of the obvious would be to provide a framework for a rule or guidance on how to interpret it, which is useful. But the service animal policy was intended to be a set of restrictions that would govern exemptions to the no pets rule. And the member said, well, that policy, it's not effective. Okay, it was pre-Boudram. We wouldn't have done it post-Boudram, but we move on. What the board had also said, and what we argued, was the first thing is we're providing accommodation under the code. We're doing this in a way that balances the competing human rights code interests of everybody in this property. We're doing this under a couple different authorities. First of all, what's called the business judgment rule, which is a rule about deference that courts and tribunals have to give to the judgment of a board of directors of a condo, of a private corporation. And we also argued that we're balancing this under what is articulated by the Ontario Human Rights Commission's policies about ableism and about balancing competing interests. And there were lengthy arguments that happened, but the long and short of it was the member found that the condo has offered reasonable accommodation to Mr. Martis and his needs for an emotional support animal. Mr. Martis has not established that he needs a heavier dog, and that's in the 25-pound weight limit. The condo is not obligated to accommodate his preference for a specific dog when that dog exceeds the weight limit that the condo established when the weight requirement was set to balance other code-related needs. And that's kind of one of the closing paragraphs of this case. But digging into it, and there were a bunch of arguments about the policies that the Human Rights Commission puts out and the ableism policy. And that's the policy that you look at about how do I accommodate somebody? What do I have to do? What's the medical information I need? It's really valuable. If you've got human rights code concerns, you need to go look at that because it's plain language, it's well cited. And the member said, hey, the policy contains a relevant distinction, between when somebody needs accommodation and when they say, I need accommodation, but I would prefer this outcome. And the member really found that Mr. Martis was saying, I need accommodation, but I really want this big dog. But he didn't give us any medical information. We actually had a medical letter. It's part of the record from a doctor that says, I'm not prescribing a certain size of dog. I'm not prescribing a certain type of dog. So there was no medical need established for having a large dog. And the member then said, hey, she accepted the testimony of our witnesses that there are other people at the property, at the condo, who have code-related needs to avoid dogs. That's why we're allowed to balance these competing interests and set a weight limit and certain other reasonable restrictions on how you move a dog around the property. The only real restriction that they really objected to in this case was the weight limit. Everything else was not really the subject of this case. So kind of what are the takeaways that we get from this? A couple of takeaways are, first of all, the cat said, hey, if you want to do restrictions about dogs or animals that are there as an exception to a rule, you should really have a rule that sets out the exemptions, which is kind of a pain in the rear end potentially. But okay, pass a rule that says the board can do restrictions on your emotional support animal accommodation. For this condo, it would make sense because they have no pets rule. So maybe we need to look at doing a rule about weight limits and that sort of stuff. The other takeaway, one of the big ones, was follow the policies from the Human Rights Commission, implement them and use them. The CAT had also impugned, hey, the process needs to be clear when somebody requests human rights code accommodation. needs to be kind of very clear. There are some factors that kind of muddled this up in this case. We also found that the CAT will look at human rights stuff, not only when it comes up just in the context of a case, like somebody's parking wrong and they say, well, I'm parking wrong because I've got a disabled parking placard, I need accommodation. But in this case, the entire pith and substance, so the entire substance of the case was human rights accommodation. And there was a ruling about that where the CAT said, well, this came up in the because it's pets and condos, you've got a pet rule. So we're going to look at it. And something that we'll talk about maybe a little bit later in this is the CAT is not cost effective. It isn't cheap. The Martis family, they asked for $25,000 in legal costs, plus $1,500 in just general damages. Because they lost, they didn't get that. The condo, on the other hand, we did not ask for costs because had this gone to the Human Rights Tribunal, where it ought to have been, in my view, the Human Rights Tribunal doesn't award costs. But they say they spent $25,000 on the case. I know what the condo spent on that case. You're well over $50,000 in litigation costs before this tribunal, which is not cheap, effective. And it also took, I think, about 8 or 9 months to get to this final ruling because of how awful the CAT's processes are, in my view, and everything that went on with that. So, but main takeaway, condos can set limits if they make sense in the context of the accommodations being requested, and if the Human Rights Code and the OHRC policies are followed. I'll hand it back over to Sonja.
Thanks, Gareth. And, it's nice that they came to that decision because that upholds a decision I did many, many years ago, SCC 89 in Dominelli, which also upheld the ability to impose a weight restriction. So nice to see that they're following at least in those footsteps and keeping that line of case law going. One of the cases I was going to talk about, I'm just going to mention it briefly because it kind of ties into what you were talking about, and then we'll pass it over to Patricia, was a case that I did earlier this year, Teeter and SCC number 8. And this was a parking issue, and it was a request for accommodation was one of the issues that was being dealt with. And I just wanted to highlight the fact that requests for accommodation, as Gareth said, are based on needs. And so if the need no longer exists, then the accommodation dies. And so what the Teeter case was about was a motion that we brought to dismiss the application at stage 3 because the accommodation no longer was required because unfortunately the person who required the accommodation passed away. And we were successful on that motion. We weren't as successful on the cost issue. We only got $1,000 in costs. But it's important to note that when that need dies, so does the accommodation request, and you should try and bring a motion to basically end the case so that you're not continuing to incur costs. So we've talked about a lot of the new stuff that CAT's been dealing with under their new jurisdiction, but I'm going to pass it off to Patricia because Patricia's going to go through some of the cases at CAT that dealt with records and adequacy of records and redaction of records, which is their original jurisdiction. So Patricia? Oh, Patricia, sorry, there's something wrong with your audio. Do you want to try muting yourself and then maybe unmuting again? Go ahead. No, go ahead. No. Okay, why don't we do this? Patricia, why don't I talk about costs that I was going to talk about and see if you can get your audio fixed, and then we'll come back to you. Okay, so we said we were going to talk about costs in more detail, and I'm going to start off this discussion about costs and talk about costs at CAT. And I wrote an article for Condo Business magazine that came out about mid-November. You can Google it if you want to read it. But it talked about 2 decisions this year that we got from the CAT on costs and how they're good examples of why lawyers such as Patricia and Gareth and I are so frustrated when it comes to CAT and costs, because they come to opposite conclusions and they don't provide any clear reasoning as to why we're all over the map on costs when it comes to CAT cases. There have been some cases that have actually been successful in getting costs. There's even one that I'm going to talk about that got all of their costs. But then on the other hand, hand, there's lots of cases where we have an owner behaving badly and the costs are not coming back to the condo corporation. And this really is offensive to us as condo lawyers, because there is a general principle that the courts have accepted when the courts were dealing with these issues, was that it's not fair for innocent owners to have to pay the costs that are incurred as the result of one owner who decides not to follow the rules. And there's a lot of court cases where costs have been awarded to the condo corporation on that principle. But it doesn't seem that, although the CAT jurisdiction continues to expand and more cases are being transferred from the courts to CAT, excuse me, it doesn't seem like CAT is adopting that principle. Although they keep referencing it, it doesn't seem like they're implementing that principle. So the first case I wanted to talk about was Middlesex Vacant Land Condo Corporation 605 versus CUI. This came out in October of 2021. And in this case, the condo corporation was successful in enforcing its governing documents and in getting some costs. Now, the condo brought a claim because the owner's dog was barking excessively and the owner didn't clean up after the dog. So this was a nuisance pet type issue. The order from CAT was that the dog had to be removed and the owner had to pay costs of $8,273.56. Now, one would normally think that if the condo corporation had to go through all of this steps at CAT to get an order that actually required the dog to be removed from the condo, that the condo would get their costs, but they only got 38% of their actual costs, which, you know, that means that the rest of it, 62%, are being paid by all the other owners. And that just doesn't seem fair when you have an owner who is completely and blatantly not following the rules. And in addition, the CAT in their decision talks about, you know, it's a serious matter to require someone to remove their dogs, which they did. And it's a serious matter when condominium residents do not conduct themselves in a way that are considerate of neighbors and other owners. This is the language in this case. And they say that a condo corporation, to ensure the protection of the interests of all owners and residents, they must be able to enforce their governing documents, which is what the condo did. But despite all of that, they're not going to give a condo their full costs. And that means innocent owners are paying. And they basically try to justify this on the basis that their hands are tied because of the policy that is in place, the rules of practice that are in place at CAT. So it's unfortunate that this is the approach that was taken in this case, and this is the approach that's taken in a lot of cases. But you know, it's very, very frustrating because we do have another case at CAT, which is the Peel Condo Court case 96. I'm not going to pronounce this properly, but I'm going to attempt. I think it's Sofimis, Psofimis. This case was actually referenced in the CU decision that I was just talking about. And this is another 2021 case from CAT. And in that case, the CAT awarded full costs to the condo corporation against an owner who also breached a pet rule. And fortunately, in this case, and unfortunately in CU, they didn't make that distinction between pre-CAT costs and post-CAT costs. So this is another frustrating thing about the case law coming out of CAT is in CU, they said the cost the corporation incurred up to the time the CAT process started, we're going to give you 100% of those costs back because of your indemnification provision in your governing documents. But we're not going to give you 100% of your costs for the costs that are actually incurred at CAT, which is where most of the costs were incurred. They only gave 25%. But in the Peel Condo Court 96 case, they didn't make a distinction between the pre-CAT costs and the costs incurred during the CAT process. In the Peel condo case, they reaffirmed that the innocent owner principle applies and they awarded legal costs as damages under Section 1.4413 of the Condo Act and under the tribunal's rules of practice. And they found that this case, that there were exceptional circumstances as the condo was forced to seek an order from the tribunal because the owner deliberately and repeatedly ignored the numerous attempts to request voluntary compliance. Now, this all makes sense. This is what should be happening. But it's hard to reconcile this case with CU and some other cases that have come out at CAT that are not applying the same principle. So we have these competing cases at CAT. They seem to make distinctions between pre-CAT costs, which seem to be easier to get, and CAT costs during the process, which don't seem that easy to get. And then you don't know what to do. You don't know what's going to happen. And part of the purpose of courts and tribunals and having decisions and having precedents is so that people are aware of what's going to happen when you take certain actions. And the fact that owners can bring, many applications to the CAT at very little cost to them, without any serious consequences, means that condo corporations, and when you say condo corporations, we're not talking about for-profit corporations, we're talking about a group of owners. And I really wish they would change corporation to association, because there's a lot of misconception when people hear condo corporations. They think there's a big pile of money there. But at the end of the day, it's the owners who are paying. The innocent owners that are paying for the actions of owners who are behaving badly. And that just doesn't seem right. It doesn't conform with the principles that we used to have and that used to be enforced. And hopefully CAT will be changing as we move forward and as they get into more complicated issues that they're going to have to decide. But right now, it doesn't look like that's happening. There was a case that was just released a couple days ago, the Calderon case, yes, which we talked about on the cost issue. And Mr. Calderon withdrew his application just as stage 3 was pretty well complete. And he was able to just withdraw his application with no cost consequences. So the Condo Corp had to incur, again, a ton of costs, but they weren't able to recover it, even though the owner just withdrew the application. So it's very frustrating for condo corps because they are incurring a lot of costs. They have to explain those costs to their owners. And then on the other hand, they have this obligation to enforce their governing documents. And even when they're acting reasonably and they're doing everything they should be, they're still not getting their costs back. So that's my rant for today. But what I want to do is I want to open up this discussion, and I want to see.
Can you hear me?
Yeah, we can hear you.
Okay,
I want to see what Patricia and Gareth has to say. But Patricia, before we get into this discussion, because I know it could be quite a long one, do you want to do your cases, or do you want to do this? Do you want to do this cost decision?
You're on a roll. So let's go to the cost, because I feel like I have an opinion about this too. Okay. And some of you may know that because, and I'm just going to continue along the thread, because I think that there are a lot of people who supply valuable services to the condo industry, property managers, accountants, lawyers, you name it. We're all professionals. We do our work. This pattern of not paying for the costs of legal diminishes the service that we do in some ways. It also discourages advocacy that is well educated in the law. And that is very important to defending the positions of corporations. Now, I will point to Dominelli. Dominelli was an excellent case, well argued, well structured as evidence, and proved a very important point, which is don't abuse your human rights, accommodation rights, and don't tell lies to the corp, and be very clear. But it also showed that boards can ask questions. So when you're actually doing the work of a lawyer and the corp is your client, or even a unit owner is your client, you can go to court and you can get some of your costs. And the courts will also tell you, you did not behave well as a lawyer. You're not getting all your costs, let's say. But here, where there's a complete isolation, I think it's been I think it's time to rewrite the rules, to be honest. Rules were written to create the cat and the parameters. The rules can be changed. They can mirror the rules of civil procedure. But even more importantly, look at what we've bought into as condominium owners. We've bought into the principles of indemnity. We've brought into the principles of Section 134, which is if you are liable for breaking the rules, you can pay for it. And what this is doing is it's circumventing the whole structure, even the principles that we buy our condos based on. And I don't think, honestly, that you can actually do that. I think you're contracting out of the act at the highest level, because what you're doing is you're changing the rules of engagement that people are putting their life savings into to live within those parameters. Sorry, Gareth, I have an opinion, but I should jump to you.
But it's a great opinion, and B, I agree with Patricia's opinion, which is not always the case. And
True.
C, my webcam keeps showing you my shelf in the background, so I'm sorry about that, everybody. You talked about the rules, rewriting the rules of the CAT, and there's a comment here from Rob Russell. The CAT and the CAO did do in consultation about rewriting some of the rules, because there's Rule 46.1 that says the CAT will not order a user to pay another user any fees charged by a lawyer or paralegal unless there are exceptional reasons, and there's case law on that. We all put in for this consultation. Rob Russell had mentioned the consultation. I would say it's over. It closed very, very quickly, and I wasn't pleased with how the CAO structured the consultation. They put out a number of scenarios that were, quite frankly, disingenuous about cost recovery. And the CAO and the CAT, they've got the power under the Statutory Powers Procedures Act, which is getting really technical, to order costs if they want to. They can do that, and they need to follow what the courts have said and what Patricia said. The thread of my declaration says I don't have to pay for what my neighbor causes our condo to incur. So why, I bought into that. Why am I paying for that? And Rob Russell said, it's a really good comment, Rob. The CAT doesn't seem to look favorably on corporations that retain counsel for CAT cases against self-represented owners. They seem to feel that there should be equal representation and that boards or managers should be competent to represent corporations against self-repped owners. And Rob, and that's a good comment, and it's very dangerous actually for condos to be self-repped against self-repped owners. CAT cases are not straightforward. They're not easy. The Martis case, Mr. Martis, he had lawyers, and there were objections and all sorts of arguments. And if you go look at Section 37 of the Condominium Act, directors are encouraged to rely on the advice of professionals. The advice of professionals, as Patricia says, includes your lawyers. So it's a poor idea for a condominium corporation to say, well, they're self-rep, so I guess a director is going to have to sacrifice their time out of their lives or their family, or you're going to have a manager. And Debbie, as a manager, you're going to say, I don't want to go to, and as a manager, you might actually have in your management agreement, if we have to go to CAT and represent you guys, we might even have to charge you, the condo, more fees. It's a very poor idea to penalize somebody for having legal representation. So, and that does seem to be where the CAT is going. And then Sonja mentioned the recent Calderon case, where I think he had 8 cases going. He got all the way to the tribunal stage. The condo spent a lot of money defending all those cases. They said, well, sorry, bye. And the CAT let him off without any
he's selling his unit now.
Yeah, with no consequences. So the CAT does need to relook at what they're doing, how they're doing it, and how they're making everybody whole. It's the principle that the loser pays. The winner gets made whole in part or in whole, and the CAT needs to go follow what the courts have done over the decades, really.
I think there's another important point here. Managers are not members of the Law Society of Ontario. They are not the professionals that provide legal advice, and they're not trained advocates. And I'm pretty sure their commercial insurance doesn't cover this. So I've been involved in some CAT disputes where I'm working actually for the manager that has a conflict of interest in the interest of the board. The board is actually looking to the manager. And then, I think it puts a really heavy onus on managers who feel pressure to advocate this. But, my expectation isn't that there isn't a special cost schedule either, that it falls all within the property management fees. But, I don't think that managers are advocates, and Debbie, you may want to jump in here to clarify that, but, I just don't feel like that's an appropriate passing of the buck. It's not the corp, it's their agent that's doing the work.
Now, I have to agree, Patricia. I mean, if it even starts to go to CAT, my company will not get involved at all. We have a clause in our management agreements. It's a legal matter. Legal matters are handled by lawyers because it's a legal matter. And our code of ethics that we abide under the Condominium Management Regulatory Authority of Ontario for our licensing actually requires us to refer to the correct experts and other professionals. So legal matters, go to the lawyers. You guys can handle them. Thank you very much.
Thanks, Debbie, for jumping in there. There's another case that I just wanted to highlight on the cost issue. It came out in November of this year, and it's TSCC 2370 in Chong. And this is another case where a dog was ordered to be removed. The CAT referred to Peel Condo 96 case again, but only gave 100% of costs for the pre-CAT procedures, 50% of costs during the tribunal process. But the kicker is this involved a tenant, and the CAT said that the owner made all reasonable efforts to make sure that their tenant complied. And so then they just ordered cost against the tenant, not even against the owner, which means you can't lien. You can't add it to the common expenses of the unit because the costs aren't against the owner. And good luck trying to collect costs against a tenant. So in essence, the condo got no costs because they're not going to have probably much luck trying to collect these costs unless the tenant, has a job that they can try and garnish wages. There's no unit to attach it to. It's just going to add more cost to try and collect the costs that they got. So again, very frustrating for condo corps and the innocent owners.
One of the important things to remember too is that units have equity. That's why, the enforcement should come very quickly and swiftly. I don't disagree with that principle. I don't disagree with, trying to get resolution quickly and sensibly, right? Like, I don't really like the idea that people lose their units. I don't think that's great. But at the same time, I don't think people should be allowed to walk away from their messes. I don't think that people should, just because the CAT doesn't award cost doesn't mean there's no cost. Right? If you look at some of the cost awards, like in Senec, our trilogy of cases where we didn't start the dispute, I being the condo corp, the unit owner did, the costs were $110,000 by time we had dealt with all the complaints to the Law Society, because she complained against 5 lawyers, 3 of whom had never even touched the file. And she kept bringing motions and additional proceedings. So should a small townhouse complex in Ottawa have to pay $110,000 because somebody decided that they felt that they were right and she was proven to be wrong in every single one of her issues? Right? Like, that's not why the condo legislation was drafted that way. It was to find a fair balance that you're not going to pursue an issue because there's a penalty to you. If you're wrong and you're misbehaving, the corp is going to be able to put all that cost back on you. Similarly, if you feel that you're being oppressed by the condo, you can bring an oppression action. But right now, those mechanisms are out of balance, out of whack, right?
And I might say that we saw things, and before my time, maybe swing a little bit too far towards the condo. They've swung back around too far, potentially towards the unit owners. The courts seem to be in the right place. Like the case that we mentioned, was it 2204 and Penig E2, where the court said, why are you here for over $1,000? Like, that is proper, no costs. Like, go away. So the CAT really needs to look at and say, how do we balance this now that we've had all this feedback? And the CAO needs to do that. And they need to hear from unit owners who say, please make sure this is fair for everybody.
Yeah, and that answers one of the questions in the chat about, how do we get CAT to change this? As condo corps, as unit owners, you're paying a fee to the CAO to manage CAT. That's part of their mandate, and you should be writing letters to the CAO and raising these concerns with them. Even though the period for the feedback that they sought is over, that doesn't mean you can't write and raise these concerns to them directly. But Gareth, just on your comment about the court is in the right place, I don't think the court always gets it right, because the recent case we got in Friend is an example of where the court, I think, with all due respect to the judge, I think got it wrong, because in Friend, again, this is an Ottawa case, the condo corp didn't get their costs, part of their costs that they were seeking for compliance, because they didn't have a court order. And the court, using Emlani, I didn't want to say that word because I didn't want to bring that whole thing up, but I can't get around it. But using the Emlani case, which I think they used wrongly, said that you can't get compliance costs unless you get a court order. And that is not true. The Act itself specifically allows for your declaration to have indemnification provisions. So, I think the court got it wrong in the Friend case on costs, because I think if you have a properly worded declaration with an indemnification provision, you fit within the four corners of the Act, and you should be able to get your costs that way. So courts don't always get it right, but I think it's easier to appeal a court decision than to judicially review the CAT.
Exactly. And I also think another thing that we all need to think about what's happening around us is that we're being downloaded with costs. And I'm talking as a condo owner. We're actually paying extra for this whole infrastructure, and the downloading of the costs of defending our declarations, our rules, is being paid now by all the innocent unit owners. That's the fundamental issue. But the bigger picture that worries me, which has come up in a lot of the areas that I've been speaking on, is affordability in the long run. If, like with Garrett's case, if you'd been able to go to the Human Rights Tribunal, your insurance would have covered the cost of defending that, right? And I know insurance is also a touchy subject. I'm going to talk a little bit about that as well. But your defense costs for the corp would have been covered there under the policy. So, I think we also need to think about, when does affordability of just the operations become unaffordable? And are we actually being set up for a path where common expenses start to escalate because the cost of enforcing now has become actually the corp's operational cost? And you do have to enforce, because otherwise someone's going to sue you under 135 for oppression because you didn't comply and make sure that 119 was enforced against.
Although, Patricia, condo corporations, especially smaller ones, might say we can't afford to enforce our rules, our declaration, because the moment we do that, we know this is going to kick off and we can't get our costs like this.
So what you're going to end up at CAT because an owner has taken you to CAT for not enforcing. There's cases at CAT that owners have started because the condo didn't enforce. Right. So where do you go, right? Which road do you take?
But I think that was the brilliance of how the Condo Act was drafted, right? Because the person who's doing the wrong is going to pay the fee. So they're going to think twice and be discouraged by the penalty, which the courts have said is reasonable, or they're going to, or they're going to fight you, but then they're going to have to pay the bill. Like in Seneca, what was the dispute? It was a dispute about a flower pot on the common elements that they didn't have a right to put on the common elements. So politely asked to move it, doesn't do it, actually stands in it and refuses to move. What are we going to become lawless then? Is that what condos will be? Because we've forced people and told people to buy into these structures. And then we're going to say, yeah, but you know what? As a fourth level of government, your hands are tied. You're going to pay the whole cost. Guess what? Common expenses are now becoming taxation.
Yeah, I think
not for real costs.
I think a really important point, and there was a comment in the chat that I think we need to address as well, is, when we talk about innocent owners, it's not just innocent owners as the corporation. If the corporations are behaving badly, the innocent owner is the owner who's bringing the CAT application because they're being oppressed by a corporation. So I think, that concept of innocent owners runs both ways. it's really innocent parties, right? The
Yeah.
person who is not behaving properly should be paying the costs. The people
Whether
that
it's the
are
condo or the owner, absolutely.
behaving properly should not be paying the cost. And that doesn't matter whether it's the one owner who's being oppressed or the group of owners who are being oppressed because somebody's behaving badly and doesn't want to follow the rules. That should be the general principle. If you're not going to follow the rules and live according to the rules of that community, one, go find another community whose rules you might like better, or two, you're going to pay the cost consequences of it. And that is what needs to be, that's the message that needs to be sent from CAT. There needs to be a real hard deterrent. They're prepared to levy $1,000 penalty against a condo corp for not filing their response to a request for records as a deterrence. They should do it the other way around as well. They should be sending those strong messages in terms of deterrence for people who are abusing the CAT process, for people who are not following the rules, regardless of what side they're on. And then that would be very consistent and clear and fair and fall in line with what the whole idea of the Condo Act is all about.
Yeah.
That's my piece for the 2021.
There were a couple just kind of interesting comments and questions that just popped into the chat about costs. Thomas Tucker says, I'm not a lawyer, but even though the CAT doesn't award costs, is there an opportunity to get costs through like small claims court or anything else like that, other levels of judgment? And Patricia is shaking her head, Sonja shake. Debbie's, the quick answer is no. The CAT is pretty much supreme in their costs. You can appeal a CAT award to the divisional court of the divisional court, which is like a level above the superior court, below the court of appeal. Very expensive. You can only do that if you think the CAT has been wrong in the law, how they've applied it. And it would be very expensive, I think, to make a cost appeal on that.
It would cost you more.
Oh yeah, your cost benefit would be out of whack. And then Gabby Arado has asked, can the board add a new rule to the rules for owners to pay for any complaints filed with the CAT to pay for legal costs if they lose the case? And the CAT
amend your deck.
Sorry?
I'd say amend your deck.
Yeah.
Amend your declaration. Yeah.
Because you have to abide by the deck unless it's outside of the law, right? So I think that's where we're going to go. We're going to go with looking for condos to start amending their decks to be broader in their indemnification provisions. Like, I think we're going to be changing those on the corporate side.
Yeah, I think that's the best place to do it. In the meantime, I would be amending the rules just to get it in there somewhere, because there are some cases that have upheld the indemnification provisions in the rules. But ideally, the deck is where you want to put it. There was a comment from Rob about there's been cases where CAT has awarded costs because one party has been able to demonstrate exceptional circumstances. Yep. That's true, but the problem is the quantum, right? They're awarding 30% of cost, 25% of cost. They're awarding pre-CAT costs, but not the CAT costs. So although and this is interesting because their rules of practice say you need exceptional circumstances to get costs. And then there's nothing that says once you get exceptional circumstances, there's a limit on what those costs should be, which, to me, it seems like you're going to follow your rules of practice, then follow your rules of practice. Once you get past exceptional circumstances, then there shouldn't be the limit, right? It's what's reasonable in the circumstances is pretty well the test that should be applied. Anyway, we have 5 minutes left. Patricia, I'm sorry, we kind of cut you off on your records.
But, I'm totally passionate about this issue, but I'm going to give you just a quick overview of 4 cases. And I think we have.
Can you pick your best one? Because we have 5 minutes and I want you to talk about insurance.
Okay. Oh, right. Okay. So that's the other thing. So in terms of, I'm going to give you an overview summary that what you should do is you should make sure that your minutes are succinct, take them, and the cases cover, adequacy. I think that you need to be very careful when you are redacting. One of the cases, Chai and TSCC 2431, gets into adequacy. And when I looked at the case, one of the things that disturbed me here, because the CAT ordered that the corp should go back and look at their redaction. But if you look at what was redacted, there were 2 sections that were specifically redacted that related to a fire in a unit. And here's the thing, corporations should have the parameters to work with counsel to redact. Why? Because it's not going to be just about what is this unit owner up to and why do they need the minutes. It could be that they're managing litigation on a fire in the unit. So, this is the other concern is who's making the call on the actual litigation strategy, and what happens if you're forced to redact. Your redaction then reveals information that jeopardizes your case. Like, it's completely circular and it's dangerous. And the last thing is, I think as well, keep your minutes succinct. Don't incorporate notes or drafts. And if you, in my opinion, one of the things that I didn't like is that I saw that one of the minute that the unit owner was asking for the minutes to reflect motions that were made but not seconded. But that would not be valid transacted business before the court. So minutes now are going to have to be, make sure your resolution is clear, make sure that you have added to it all of the elements that were considered by the board, and some reason for the analysis. Not everything, but some of it. And I think what you're going to see is there are going to be more cases at the CAT where people are questioning the integrity of minutes. And that's very disconcerting. But, I think you also have to be careful on who takes the minutes and whether they're going to be liable if there are disputes about the minutes and what was said. As well, if you are amending minutes, please have a process. These cases show that you should have a process, but it should be articulated and you should be consistent. Sorry, Sonja, go ahead.
Okay, thanks, Patricia. I just want to let everybody know that we are going to post, when the video gets posted, a list of all the cases that we talked about today. So even though Patricia wasn't able to go through the cases on records and minutes in great detail, you'll have a list of those cases so that if you want to take a look at them, you can take a look at them yourself on Canly. There's a message in the chat from Debbie saying, hey, do you guys want a webinar on taking minutes? So if you do, please send us an email or put something in the chat about your desire to have such a webinar, and we can look at doing something in 2022. But before we wrap up today, Patricia, in like 1 minute or two, can you just talk about insurance and the consultations that are going on right now? Because we wanted to bring it to everyone's attention because the deadline was coming up. It's now been extended, but go.
All right. So yes, that's exactly it. The government, it wants your comments on insurance. As you know, insurance has been a real issue, and CCI has really addressed this over many months. Look at our webinars. But the government wants your feedback on this and what can be done. They're looking for solutions. They're open to hearing about things that you think might help you as a condo manage that cost. Now, the deadline was January 7th. It is now January 31st. CCI has a legislative committee that is actually a group of lawyers from across Ontario that are actually putting together their thoughts. If you have thoughts, send them to us. We'll make sure they get them to the committee, or alternatively, if you want to send them in directly, we will provide you with the link on how to get your submissions in. Tasna?
That was great. Thanks, Patricia. Well, I want to thank Patricia and Gareth for joining me today. It's always fun to talk about cases and costs, which seem to be the predominant discussion in this webinar, but I hope all of you enjoyed it. I hope you got some takeaways from the cases and some lessons learned to make sure that next year you're on Santa's or the CAT's or CAO's nice list, not their naughty list. I also want to take this opportunity to once again thank our sponsors. Without their support, as I've said many, many times, we're not able to provide these webinars to our viewers free of charge. But with the support and the generous support of our sponsors, Integrity Property Management, Elia Associates, Condominium Lawyers, and FCS Fire Consulting Services, we're able to continue to provide you these webinars on a regular basis. So thank you once again to all of our sponsors. Thank you to our speakers. Couple notes before we wrap up today's webinar. The recording will be on the website next week, as well as the citations to the cases that we mentioned. Don't forget to mark your calendars. CCI Huronia is going to have an Intro to Condos course on January 27th from 7 to 9. p.m. Details about this event can be found on our website, ccihuronia.com. We will also be launching our webinar series for 2022 in February. So stay tuned for details. Check us out on Facebook. Check out our website after the holiday break, and make sure you get on our email list so that you get all of the information as soon as it's released about our upcoming 2022 webinar series. If you have any suggestions for topics or speakers for our upcoming webinars, please send an email to admin@ccihuronia.com. In terms of upcoming events at other chapters, there's really nothing much happening before the end of this year, but if you want to find information about webinars being held at any of our other chapters in 2022, check out the CCI national website, cci.ca. Scroll down to the bottom, you'll see upcoming events, which will list the upcoming events for all of our chapters, not just across Ontario, but also across the country. You can then click on that on the link to go to that chapter's website to actually register. So cci.ca to check out upcoming events. So that's a wrap for today. Until next time, I'm Sonja Hodis from the entire CCI family to your family, wishing you a great weekend and happy holidays in whatever way you celebrate it. Be smart, stay safe over the holiday break, as we definitely want to see you on our next webinar on January 27th. And don't forget, CCI is your condo connection.